There's a global war on wealth. Learn about how to own your freedom, control your time, protect your wealth, and preserve your legacy. The only place for unfiltered discussion about what impacts your wealth. The Sexton Show.
Hi, today we're going to be talking about foundations, and not the type of charitable foundations you're used to hearing about in the United States, but civil law-based statutory foundations, which are often used kind of like trusts. And joining me today is Instagram style sensation, Virginia Jeker, who also does a little tax lawyering on the side. But just kidding, in all seriousness, Virginia is an international tax attorney. She's been barred in New York since 1984. She's based in Dubai for, I think, over 20 years at this point. She is probably the most brilliant international tax mind that I've ever come across. She has a great blog. We'll put the link down in the description. And she's written a bunch of fancy articles for publications such as Tax Notes International. Did I miss anything there, Virginia?
No, I think, Jimmy, you're making me sound absolutely wonderful, and I hope it's all I hope it's all sincere and true.
It absolutely is. Like I've told you before, Virginia, my goal is to be you when I grow up.
Okay, well, I appreciate that. Thank you so much.
So let's start off with a brief overview of foundations, because one of the things that I've found, especially when I talk with US clients, when I talk about, maybe let's look at a foundation rather than a trust, is, like the Bill and Melinda Gates Foundation. And they think about them completely in a charitable context. And that's not really the type of foundation that we're talking about. So,
correct. I think the reason people are not so familiar with foundations in the United States is because the US is a common law system, and the foundation is actually a concept that arose from civil law jurisdictions, so that would predominantly be in Europe. A foundation is actually a creature of the law of the particular country that has a foundation's set of laws that you would follow to set up this foundation. And certainly they are not looking at charitable foundations the way people in the US think of them. These are foundations that are set up by private individuals, generally for their own family, to protect their family wealth, to pass it on through generations, and also for especially asset protection purposes. So it's very different from the US idea. But having said that, the concept of foundation has become very, very popular, and people are seeing how excellent it can be as a tool. And the US now has at least 2 states that have set up these foundation laws so that people can set up private family type foundations that wouldn't be treated as trusts, or they wouldn't be treated as corporations. And right now we've got Wyoming and New Hampshire on the bandwagon. So the idea of foundations is becoming far more popular than ever before.
Yeah, and I think that there's also, the US, I think, is probably the most major common law jurisdiction to add foundations. But I think there's a lot of other Commonwealth jurisdictions that are former British territories or crown dependencies or something that have added foundation laws to their laws and have been around for I think probably going on 10 years in several of those jurisdictions. So you would use one of these private foundations sort of for the same purpose that someone would normally use a trust for, correct?
That's right. I think that's a very good way to think about it.
And so there's also similar parties to a foundation as there are to trust. Like there's a person that sets it up, and then there's managers, and so on and so forth. So if I remember correctly, the founder is attuned to the settler, the person that's starting it. The beneficiaries here in the UAE, they're called qualified recipients, or designated persons or qualified recipients. And depending on the jurisdiction, they can have a different name. Those are equivalent to the beneficiaries. And then we have a guardian, which is equivalent of a protector. And then the nice thing about a foundation is, and I'll let you get into this a little bit, is there is no separate trustee. It's self-managed. So you generally have a council, which is much like a board of directors, that is the equivalent of a trustee, has the same function as a trustee, and manages the assets, correct?
That's right. The big difference between that governing body, the council, and the trustee is that with a foundation, the assets are actually held in the name of the foundation. So they're owned by the foundation legally as a separate legal entity. Whereas with a trust, the trust is not really a separate legal entity at all, but the assets are owned legally in the name of the trustee, but he holds them in trust for the beneficiaries. And that whole separation of legal title and beneficial title can cause some issues that you really won't have when you have a foundation. So I think that's the beauty of the foundation. There's a cohesiveness of ownership of legal and equitable title to the assets. You don't have to deal with a trustee entering into an agreement with a third party. The foundation does it in its own name.
I think this is one of the things that confuses people so much with trusts, is that because people say you're putting something in trust, a lot of people believe it is an entity like a corporation or a foundation, when in fact a trust is just a contract between the settler and the trustee, and you can't put assets in a contract. It has to be titled in somebody's name, in this case, the trustee. And so I think there's a lot of advantages of foundations over trusts in terms of their usage and their benefits. One of them, which we just discussed, is the fact that they own assets in their own right. They have their own internal management structure rather than a separate, rather than a trustee. And I think one of the other nice benefits with that is a lot of times when you set up a trust, the trustee, if it's not an individual, has to be a licensed entity, meaning you have to go hire a professional third-party trustee to manage this trust, whereas foundations, generally, you can elect the founder, the person that sets it up, can elect the council members, and which could be family or trusted advisors or things of that nature, rather than a trustee. But I think there's some other benefits too that you can touch on.
Right. I think, and you can give me your view on this, Jimmy, but I think you may have a much stronger protection, asset protection, if you use a foundation as opposed to using a trust. And the reason I think this is, I think that separate legal ownership within the foundation and the foundation laws regime that will protect from foreign judgments, for example, being enforced within that jurisdiction, gives the assets stronger protection than I believe you would have with a trust. What do you think about that?
I completely agree. And I think that there's another aspect to the foundation that also strengthens the asset protection that it offers over a trust. And that is that with a trust, the beneficiaries have an interest in the trust, whereas with a foundation, the beneficiaries do not. So there's no fiduciary duty of the manager, of the council vis-a-vis the beneficiaries or qualified recipients of the foundation. And I think that fact gives the beneficiaries of a foundation much stronger asset protection because they have no interest in the foundation itself. It's not an asset.
Correct. Let's just expand on that a little bit. So for example, I think what you're saying is, let's say there was an ex-spouse of one of the beneficiaries of the trust. She may try and claim some assets from the trust because the beneficiary, her ex-spouse or his ex-spouse, has some kind of beneficial interest in the assets in the trust, and will try and get the court to give some of those assets to the ex-spouse because of the beneficial interest that the other spouse has. You would never be able to get past step one with a foundation.
Correct.
With that kind of argument. So having a foundation allows the person setting it up and the beneficiaries to not worry about creditor claims to a greater extent than if they were in a trust. And this would mean, for example, they really don't need to worry so much about the validity or enforceability of a prenup agreement if
Absolutely.
the assets are in a foundation. So I think these kind of practical considerations can help people understand why professionally we tend to prefer, at least you and I, because
Yeah,
we
for sure.
understand how these things work, we tend to prefer the foundation structure over the trust.
Yeah, and I think, because I think especially in recent years, one of the things that scares me with trusts is that because courts, when they're interpreting trusts, they're basically interpreting a contract. They seem to interpret it in ways that don't always make sense, but basically they interpret the trust in a way that they achieve whatever outcome they want to achieve. And there doesn't seem to be a lot of consistency all the time with how trusts are interpreted by courts. And I think that is a much smaller risk with foundations, because it's clearly set out in a foundation law. It is a legal entity, and that's not really open for interpretation, or much less so, in my opinion.
That's right. I think much less so is absolutely correct. For sure, for sure. And that's very important when it comes to asset protection. Very important.
So I want to get into a little bit about how the US views foundations, because as we were talking about, it's not a common law entity. It does exist now statutorily in the United States, in Wyoming and New Hampshire. But if an American, for example, wanted to set up a foundation, how would the US tax it? Because it's not really a corporation, it's not really a trust. So what are the tax consequences? Because I know that that's something that makes a lot of clients very nervous, is like, well, how is this thing taxed?
Right. Well, that's a very good point. The foreign foundation can be taxed either as a foreign trust or a foreign corporation. And the difference is critical. I mean, any international tax expert will know if you have a foreign corporation with deemed US shareholders, then you are being dragged into an extremely complicated system of taxation for those US shareholders who would be, really the beneficiaries of the trust. So, rather, of the beneficiaries of this thing that the US tax system classifies as a corporation. So you need proper drafting to ensure the desired tax treatment. The desired tax treatment is usually always going to be, you want it treated as a foreign trust, because then you will avoid all these anti-deferral regimes of PFIC and CFCs and so forth that can make life extremely complicated.
And expensive.
Oh my goodness, yes, very expensive. And now we have GILTI tax, which if you have a foreign corporation will make things even more expensive for you. So you don't want to be treated as a foreign corporation. You want your foundation to be treated as a foreign trust. And so you've got to look to the drafting of the organizational documents as a main point to make sure the drafting is done correctly, that this thing will have more characteristics of the trust than the corporation. Not only do you look to the organizational documents, you're going to be looking at what are the activities of this entity. Is this trust just really preserving and protecting property for these people who cannot do that themselves? These are the beneficiaries of this trust. So if you distinguish that from a corporation, the corporation is owned by people that are engaged in a business. The corporation is actively running some kind of business. It is not there to preserve property for people down the road. It is actually engaged in business and doing some kind of business activity. So they will not only look to the organizational documents, because you can call it a trust if you want to, but if you're engaged in an active kind of business, it will not be respected, even though you've labeled it as a trust. So you will look to the intent of the individual setting it up. You will look to the organizational documents, and you will look to the actual activities that are ongoing in this entity. And all of those factors together will allow you to make the tax classification. And if you have a proper tax professional working on your case, then you should be, pretty secure that this will end up being treated as a foreign trust rather than a corporate entity.
And who makes that decision of, okay, this is a foreign corporation, or who is or it's a foreign trust? So whose decision is this to say, okay, it's this way or that way?
Well, let's say you and I were working on a case and we've determined it's best that it be treated as a foreign trust, and we do everything in our power to make it happen that way with the organizational documents. The client understands they're not running a business through this, and so on. And then you file the tax returns in accordance with the treatment of this thing as a trust. There's certain foreign trust reporting forms that need to be filed, for example. If the IRS were to challenge that and audit and say, we don't know if this is really a trust, send us everything. We want to see the organizational documents. We have questions. They send informational document requests to you. That audit will be the ultimate, let's say, arbiter of what this thing is. And of course, if the IRS came down and said, well, it's a foreign corporation, you owe X, Y, and Z in tax because it was a CFC or a PFIC, then you may petition the tax court or argue with them in appeals and so forth to dispute what the IRS has treated it as. I've never had that happen in practice. It's always been respected.
I've never.
It could happen if you get audited.
I've never had that happen either, and almost every trust deed or foundation governing document that I've read has always more closely resembled a trust. What I've actually tried to do in some of them is have language drafted into the foundation's governing document that, for purpose of the U.S. tax code, it's intended to be a grantor trust under the grantor trust rules or whatever rules we're relying on, in hopes that if they did get audited and the IRS reviewed it. One of the things that I've never researched, and it would be interesting, maybe this is something you and I can do in our downtime, is what the effect of an entity classification election would have on a foundation. Because that's something I've never been able to get a clear answer on. I've done some research on it.
Yes, I understand your issue there, because as I remember, if it's a trust, you can't do an entity classification election unless it's a business trust, which would be like a business entity, right?
Yep.
So I get you. I know I had looked at that once, and you fall down the rabbit hole, but as I remember from the research, you can't make an entity classification election for a trust. Okay.
Right. I think my question, which wasn't completely clear when I was doing the research, was it's not technically a trust, though, from a legal perspective. And it wasn't clear to me if the rules were talking about you can't do it if it's a trust for tax purposes, or if you can do it on an actual trust. But that's for another day.
Let's just put it this way. I think, Jimmy, the reason we're not going to really find an answer is because the US system doesn't embrace this concept of foundation. And when those entity classification regs were issued over 20 years ago, well over, I think 30 years ago, my goodness.
Agreed.
These things were not even specks of dust on the horizon, but they're coming now. Like we've noticed Wyoming and New Hampshire having them. And by the way, in their legislation, they say they should be treated as trust for tax purposes.
Oh, that's interesting. I didn't know that.
Yes.
That's helpful.
That is helpful. That is helpful.
So, and there's a difference in how foundations are. I want to talk a little bit about the difference in how foundations or the founder of a foundation and the beneficiaries of a foundation are taxed when a U.S. person sets one up versus how if a non-U.S. person sets one up, because the treatment's quite different. So in both scenarios that we're going to look at, we're going to assume there's U.S. beneficiaries. So I want to look at one scenario where it's a foundation set up by a US person with US beneficiaries. And I want to look at another scenario where it's set up by a foreign person, but there's also US beneficiaries. So let's start with the scenario where it's set up by a US person, let's say for the benefit of their his or her US children who are beneficiaries of the foundation.
Okay, before we jump into that precise scenario, why don't we just quickly look at how is a trust taxed and how is a corporation? Okay, and then it'll make it clearer when we go into the nitty-gritty. So a trust taxation under the US rules operates on what's called a conduit principle. So the trust computes its tax based on its income, and it takes whatever deductions are available to it. And this is like if it's a US trust, okay? So it pays tax on the income that it's got. And when it makes the distribution out to the beneficiaries of that income, it gets a deduction for that distribution. And that means the trust will not pay tax on the amount distributed out because it gets a deduction. The beneficiary who receives that trust distribution in his hands, he is the individual that has to pay tax on the trust distribution. So the income is taxed only once, either at the trust level or if it's been distributed out to the beneficiary to the individual level.
So no double taxation.
I'm sorry?
So there's only one level of tax. It's an either or scenario, either the trust or the beneficiary is paying the tax, but not both.
That's right. But a corporation is completely different. The corporation pays tax on every penny that it's earning there in income. And when it pays a dividend out to the shareholder on that after-tax income, so it has less to pay out, the shareholder has to pick up the dividend in his income and pay tax on it. So that's a double level of tax when you have a corporation. Now we move to your scenario with the US person setting up a foreign foundation for US beneficiaries. Okay, when that happens, there's a special code section in the Internal Revenue Code that says if there is a US settlor or grantor, the person who sets up this foreign trust, whenever you've got a US grantor and any possibility of US beneficiaries, we have this special rule that says all of the income earned by the trust will be taxed only to the US grantor, not to anybody else. So the US beneficiary, when he receives an amount from the trust, it's all going to be taxed to the US grantor who set it up, and the US beneficiary will be getting a tax-free distribution from the trust. He will not have to pay tax on that amount. However, he must file a special form with the IRS to, the forms are complicated, but he has to report that he's received something from a foreign trust, but he's not to be taxed on it.
So there's two things I'd like to add to that. So I think this statute that you're referring to, that if there's a US settlor or a grantor, if I remember correctly, what it actually says is if a US person transfers assets to a foreign trust. And the reason I make this distinction is I've seen scenarios where somebody thought they were really clever and they had some foreigner set up the trust and put like $100 into it. And then the US person transferred all their assets. And so technically that person wasn't a settlor or a grantor or a founder, but they did transfer assets to the trust. And because of that code section, that person was continued to be treated as the owner.
Right. The US tax laws don't look kindly on these clever.
No, the US tax laws are usually more clever than the person who thinks they're clever.
That's right. So they're going to always look to the substance.
Yep. So in this scenario where we have a US founder, since we're talking about foundations, and there's US beneficiaries, it's clear that the income tax generated by the assets in the foundation, so the tax on the income generated within the foundation, that the founder is going to be liable for that since he's the tax owner of the foundation. Now, if a beneficiary of the foundation received a distribution, they would have to file this form. And I believe that depending on the amount, that the founder could potentially be liable for gift tax on that.
Could be. Could be. I've never really looked into that aspect.
Yeah, me either, but I think that's something something we need to look into.
Yes, yes, absolutely.
Because
So
I
I
know,
think people may be looking and saying, well, what's the big benefit if the US founder has to pay tax on the income anyway? What's the big deal here? Why is this helpful? And I think people have to remember that asset protection is really the main benefit. Even though you have tax ownership belonging to that US person who set up the foundation, actual ownership via the creditors, for example, of that US person or the beneficiaries, the designated persons who get the actual distributions, is very different. So most of these foundation regimes, if not all of them, at least the ones I'm familiar with, say that they will not entertain any foreign judgments. So if a creditor gets a foreign judgment, a judgment rather in the United States to sue the founder of the foundation for $1 million, he's not going to be able to get that money from the country where this foundation is existing, because the foundation is a separate legal entity. It is not the US person who set it up, even though for tax purposes, he may be the tax person having to pay tax on the income of the foundation.
there's a very big difference between who's the owner for tax purposes and who's the owner for legal purposes. And adding to those benefits or the benefit of asset protection, I would also add that there's the additional benefits of estate planning, succession planning, because you can plan on who's going to replenish the board as people resign or retire or whatever. And you also get some privacy with it. I mean, we have beneficial owner registers here in the UAE, for example, but they're private, meaning that assets held by the foundation are not going to be public knowledge. And privacy is obviously a key component of asset protection. So I think there's other benefits that go along with it, in addition to those.
You need to look down the line. So for example, if you didn't have a foundation, let's just say, and the US person who has the assets passed them on to his children, he would, upon death, be responsible for a US estate tax on those assets. And the US children that receive these assets, when they eventually die, they're going to be paying estate tax. Not only that, income being generated in the hands of the US children will be subject to income tax in the United States, whereas if it is in a foreign foundation, it's owned by the foundation, the US government doesn't tax that unless this person's getting a distribution. So you always have to look at various aspects of the tax system, not just one.
Well, absolutely, because that's one of the things that I think a lot of people don't think about is they go through this process of setting up a foundation for estate planning, succession planning, asset protection, and all this stuff. And if they don't do that, then they put their kids basically in the same position they were in, holding the assets, but less of them, because it was essentially is almost halved every time it goes from one generation to the next. Every time there's a transfer, and in a generation or two, the wealth can easily be gone. Whereas if it's put into a foundation, let's talk about what happens if the US founder dies and where the tax benefit, because I think this is a good transition into how a foundation can save a family's wealth from being taxed
Mhm.
from generation to generation, because there would be one tax, right, when the founder dies,
Mhm.
but not when it passes from generation to generation if it's in the foundation, if you want to elaborate.
That's correct. So when the US person dies, if you remember, we said during his lifetime, the US founder is taxed on all of the income of this foundation. Once he dies, this foundation, from a US tax perspective, becomes what's called a foreign non-grantor trust and is taxed accordingly. So if it's only earning foreign source income and no US source income, this foundation itself will not have to be paying any kind of tax to the US government. But what you're going to need to look at is say, all right, well, we've got US beneficiaries, US designated persons of the foundation. What's going to happen to them now? Because now we've got this foreign non-grantor trust. Someone has to pay tax. It can't totally escape. And that is true. You will need to be looking at what's going to happen to these US beneficiaries under the tax rules if the foreign non-grantor trust starts to accumulate income and not pay it out in the year that it's earned. Then when it is eventually paid out to those US beneficiaries, they will be hit with a very harsh tax under what's called the throwback tax regime, which will eliminate really any benefit of deferring taxation to them. So there's special like interest charge rules that apply and so forth. But there are planning techniques that you can use to get around that scenario. So for example, you can, without getting into too much detail, but you could set up something called a blocker corporation, which will actually be a mechanism which will allow you to time when you want that blocker corporation to pay dividends out into the trust. So there are techniques that you can use. It does take some tax planning and tax expertise, but if you're a family with substantial wealth, it's certainly worthwhile to look into that.
Yeah, I don't want to get into details because it gets really technical. You're absolutely right. It requires a lot of detailed planning, because while you solve one problem with the blocker corporation, you can open up other problems like PFIC, like that blocker corporation being treated like a PFIC, which itself can result in a tax similar to the throwback tax, and doesn't really give you much benefit over the throwback tax. So that would definitely requires a lot of planning. Now, the treatment of, so now if the US person dies and we have the wealth in this foundation, it's clear that any distributions could be subject to the throwback tax, but the US beneficiaries never really own those assets because they're owned by the foundation. So the big benefit is if you said, for example, all of my bloodline family descendants, so basically my kids, grandkids, their kids, so on and so on, are beneficiaries of this foundation, then the wealth stays where it is and just the generations get replaced under the foundation without the wealth being transferred. So you don't have this estate tax issue because it's not actually transferring. You're just sort of replacing who benefits from it.
That's correct. So you're saving on big time on estate taxes with each generation passing. And I mean, as we know, President Biden, his tax plan is looking at increasing the estate tax rate. So this is very important planning that people should be looking at if they have wealth and want to protect it from the US estate tax.
Absolutely. And so the treatment of the foundation, once it becomes a foreign non-grantor trust upon the death of the founder, is basically the same treatment that you would have if a non-resident alien, a non-US person set it up, absent the specific foreign grantor trust provisions, correct?
That is right. That is right. So if we look at the scenario where you have a foreign individual, a non-resident alien, setting up the foreign foundation, and there are US beneficiaries involved, you go back to that first tax principle we mentioned, where I said, okay, the person who's setting it up if you meet certain very strict requirements for the foreign individual setting it up, that foreign individual will be treated as the tax owner for the income tax purposes of all the income being earned in the foundation. And because he's a non-resident alien, a foreigner, he is not going to be taxed by the U.S. unless there's U.S. source income being earned by the foundation, which is treated as owned by the non-resident alien, that income. So let's pretend you have only foreign assets in the foundation and the foundation is set up by a non-resident alien. There will be no U.S. tax consequence to him as the years go by. As far as the U.S. beneficiaries are concerned, they will be treated the same as those U.S. beneficiaries of the U.S. grantor, foreign grantor trust, meaning that they will not be taxed on distributions. For tax purposes, it's considered, all the income is considered as owned by the foreign grantor. So the beneficiaries, when they get something from the foundation, they're not taxed by the U.S., but they do need to file a form to say we've received a distribution from this foreign trust, even though it's a foundation. Right. But there's no tax to them. So that's the beauty of that. And when the foreigner passes away, that foreign grantor trust automatically converts to a foreign non-grantor trust. And you have the same issues for the U.S. beneficiaries that we mentioned before. Throwback tax issues. Oh, maybe we can use a blocker corporation to prevent that, and so forth. So your tax benefits will essentially be the same in both kinds of cases, right, for the U.S. people.
Right. No, so I think there's definitely a lot of opportunities for, if you're thinking, one, for asset protection, estate planning, and things similar to that, maybe not for tax benefits. If you're in the case of a U.S. grantor, the foundation still has a lot of current benefits, but the real benefits are going to be towards the long-term wealth preservation and protection of future generations. So there's a lot of benefit to it.
Yes, and I think now with the Biden administration, this is becoming a far more important consideration for people.
For sure. Well, Virginia, I think that just about covers it. Unless you have anything that you'd like to add, I think that sums up what I wanted to talk about today.
Yes, I think we've covered everything as well. And I hope that, people will come and start to read, at least in my U.S. tax blog, which you'll give a link to. I do have a category on foreign trusts, and discussion of foreign foundations would be in there. So if people want to learn more in detail, they can always start reading in the blog.
For sure. Well, thank you, Virginia, and I'm sure we'll do another podcast again soon. It's always nice to have you on. We'll talk to you soon.
Okay, looking forward. Thanks, Jimmy.
Thanks.
Bye.
Learn more about Jimmy's approach to wealth structuring and client relationships by visiting jsprivate.com and subscribing to our email list. Stay protected. See you next time.